One benefit of mediation, even if it doesn't resolve, is that it generally will give the parties an idea of what they can expect if the case were to go into litigation and possibly go to trial. So you'll have an opportunity to have this third party as a mediator who, again, is going to be a very experienced attorney, let's say in business disputes, or is going to be a retired judge who sat on the bench. And during the mediation itself, you'll kind of get a sense of where the mediator is leaning, what they're there to serve the role to negotiate the parties to a resolution, but they also kind of give you an idea of, well, what can I expect if a judge were to hear this, or what might a jury think of this, right? So after the mediation statement's prepared by both sides, it'll often be submitted, and then typically there will be a day for mediation. Now, this day and age, mediation could be conducted in person. It could also be conducted via Zoom, and it really depends on what the parties want, absent a contractual agreement stating otherwise. And even then, so long as the parties both agree to forego, let's say, a requirement to mediate in person in a specific venue, you can have a virtual mediation as well. So in this instance, let's say that both parties have submitted their mediation statements, and they are now preparing for the next step. What is that next step? The next step will be an in-person mediation with the mediator. Depending on the size of the claim, depending on the evidence review, depending on the distinction about how far apart the parties are, mediation can last for a couple of hours. Mediation can go all day and well into the night. I can recall a mediation sitting until 11:45 and still not actually reaching a resolution that day, but the resolution wound up being reached the next day after we got to a point that evening of where we were very close to the end. So what to expect during a mediation? During a mediation, you can expect to have a lot of ups and downs and have a lot of lulls. So oftentimes the mediator will bring the parties into a room together to first just talk to them, to hear an initial opening statement by each side. So that way there can be a positioning of what each side believes to be their grievance and what they're entitled to as damages. But if it's a very adversarial relationship, the mediator might split the parties up before the mediation begins. So for a party that's absolutely adamant that they do not want to see their adversary, the mediation process can be interesting because you can set it up where you never have to do so. You just can be in a separate room and then sit with your counsel and essentially proceed from there. Regardless, assuming that the parties do meet together, they're broken up, then usually they will be broken up at one point or another into separate rooms. The mediator then will speak confidentially with each side to start talking about the case, to start talking about the facts, extracting more information, getting a sense of where the parties really want to wind up, what they're willing to do, how much leeway they have off of their initial demands to see if it's possible that they can go back and forth to reach a resolution. Often during the mediation process, there is something known as bracketing that could be implemented. Bracketing is where you take financial numbers. So let's assume this isn't a dispute that involves the transfer of assets or involves taking over a company or shares in stock and all those things. We're just talking about pure money damages. You could actually have a range that the parties sort of agree to and stagger and bracket to that they'll deal with for the rest of the day. So one party might be at, let's say, $50,000. The other party might be at $150,000. And now we kind of use those as the parameters of getting to a resolution. And if we bracket properly and settlements go back and forth, the parties may wind up at $100,000. Bracketing doesn't always happen, and there's more details to that. It's a bit more nuanced, but it is a potential avenue to use when you're involved in mediation. If you have any questions, if there's any follow-up, if you want to know more about these topics, feel free to email us or call us at 646-386-0990 and send us a note. Let us know what it is that you'd like to hear next time, because we as business attorneys are here to provide value. We're here to hopefully give everybody a general sense of the legal process and educate everybody a little bit about what the law looks like. Once again, I'm Ross Pitcoff of the Pitcoff Law Group, and I will see everybody next time.